Hi, today I am going to share with you the decision of Honorable Supreme Court delivered 3 days ago, that is in May 1st week, 2020, between Bihar Staff Selection Commission and Arun Kumar. The principle what the Supreme Court took out in this decision is that the scope of interference of High Court or the Supreme Court. In other words, the scope of judicial review will be very narrow if there is no provision for re-evaluation of answer sheets. So this is the principle that Supreme Court created. There should be a provision for re-evaluation of answer sheets in the terms and conditions of the examination conducted by the authorities. In the instant case on hand, there was no such provision, and the High Court and the Division Bench of Patna interfered into the result of the examination without any provision available for interference. So without any rule of law, the learned single judge and the division bench interfered into the result of the examination. So that was set aside by the Honorable Supreme Court and created a principle that the scope of judicial review is very narrow when there is no provision for re-evaluation of answer sheets. Now coming to the facts of the case, it was a matter pertaining to 2010. Government of Bihar wanted some citizens to give appointment as class 3 posts for class 3 posts. Therefore, delegated the authority to select the servants, public servants, through the Bihar Staff Selection Commission. Therefore, Bihar Staff Selection Commission took the initiative, conducted an examination, and announced the result. And without any doubt, there was no provision for revaluation. Generally, the authorities will not insert any such kind of provision because it will disturb the result. Needless to say, it will disturb the result. So the result came out, and definitely some people were aggrieved. They approached the Honorable High Court of Bihar at Patna. The learned single judge referred the matter to the panel of experts, and the panel of experts gave their opinion, and based on that opinion, learned single judge allowed the application of the aggrieved citizens. Writ petition was allowed, and appointments were made. Now, whosoever were qualified, some people whosoever were qualified based on the examination result became disqualified after the learned single judge's order, because some questions were corrected and some answers were given the status of error. Therefore, whosoever were qualified in the primary result became disqualified in the secondary result after the panel of experts gave their opinion, and the learned single judge gave the decision. Now, whosoever are disqualified approached the division bench of High Court, and what the division bench ought to do was to refer the result again to panel of experts, which they did not do. The State Commission and the aggrieved disqualified citizens approached the division bench. They did not approach the High Court. Learned single judge at the primary, which was the primary authority in the High Court. So now the division bench, instead of referring the matter to panel of experts, interfered into the result and gave a decision which was again disputed before the Honorable Supreme Court through an SLP. Then Supreme Court referred the matter without any hesitation to panel of experts. So in fact, what the division bench ought to do was refer the matter to panel of experts, which the division bench failed to do so. But Supreme Court did not hesitate to refer the matter to the panel of experts. The panel of experts gave an opinion based on which Supreme Court decided that the scope of judicial review shall be very narrow if there is no provision for re-evaluation of answer sheets. So this is the principle which you should take note of. Now, what we can learn from this decision, how the governments will operate based on this decision in the future examinations being conducted for public servants. I am of the opinion that there will never be any such provision for re-evaluation. Therefore, citizens should adequately prepare for the examination that is conducted by the Staff Selection Commission instead of disputing the result, because based on this decision, in future, no high courts will interfere in the result if there is no provision for re-evaluation. And based on this decision, no governments will direct the Staff Selection Commission to insert this clause of re-evaluation, because Supreme Court spoke in their favor. Hope you understood the principle in this decision. Thank you. Thanks for watching. Bye-bye.